recording it. Okay, so hello to everybody who's come. Welcome to the first All Souls seminar at home for this term. And today I'm extremely pleased to be able to welcome Professor Cesar Garcia Hernandez, who is joining us from Denver. Cesar is Professor of Law at the University of Denver, Colorado. And as I'm sure you probably all know, Cesar studies the intersection of criminal and immigration law. And he's published widely on that intersection, which is commonly referred to as crimmigration, including a book that came out last year, or no, we're in 2021, the year before, in 2019, called Migrating to Prison, America's Obsession with Locking Up Immigrants. Cesar also publishes an active blog at crimmigration.com and has contributed also to Border Criminology. So I'm particularly pleased to have Cesar speak today. In his talk, Cesar will be talking to us about his work on immigration imprisonment in the US. And I'm hopeful that although I'm sure the content of the talk is going to be very depressing, I'm hopeful that there's going to be some positive bit at the end, maybe some looking forward, maybe things are going to change for the better, who can tell? But at least today in that respect is likely to be slightly better than last week. And so, as is usual with the online version of the All Souls talks, I expect Cesar to speak for about 30 to 40 minutes. Then that will leave us a similar amount of time for questions. We will hopefully run the normal system with the chat. I'm just getting that up now on my screen. So you can type a question into that, or you could just put your hand up and I'll call on you. When I call on you, can you please turn your camera on so Cesar can see you? I am recording this, so hopefully you're all basically consenting by being here, and I'm sure there was a form, but we're just going to forget about that. Okay, so Cesar, I shall hand over to you. Thank you very much.
Great. Thanks so much, Mary. First of all, thank you for the invitation to join all of you, and thank you also for that introduction. Thank you to everyone who's taken time out of this afternoon, this Thursday afternoon, to join me. It is I was telling Mary when we first got on, it was a late night and an early morning. It's 8:30 in the morning here in Denver right now, but it's several hours into my morning already, because no one asks me when they should roll out momentous shifts in immigration policy, and so it quite often does not work very well with my schedule. So here we are. But nonetheless, it's a wonderful pleasure to be with all of you. And as you all know, I'll be talking about the intersection between criminal and immigration law in the United States. So this is obviously a fast evolving area of law that here in the US occupies or appears in multiple arenas. In immigration courtrooms, administrative immigration courtrooms, it appears as migrants who find themselves facing the possibility of removal from the United States because of some criminal history. It appears inside of standard criminal courtrooms as criminal defense attorneys who are struggling to advise clients who are not or who may not be United States citizens about the risk of deportation. And it appears in the faces of people who are locked up while police forces and courts decide who will remain in the United States and who will not. So speaking to you today, of course, this is one day, less than 1 day after Donald Trump left the White House, and less than 1 day after Joe Biden returned to the White House, only this time as president, makes this conversation, I think, especially notable. Like many people around the United States, yesterday I held my breath as the minutes ticked toward noon in Washington, D.C., when the transition from one administration to the next officially occurred. The violence that we witnessed 2 weeks earlier at the United States Capitol, violence that was in no way surprising, but was sadly in every way distressing, did not repeat itself, not in Washington and not in places like Denver, the capital of Colorado, and other state capitals throughout the United States that were seriously concerned about the possibility that that might visit our communities, even away from DC. The United States, of course, is no stranger to violence. Ours is a political community that is frequently racked by bloodshed. School children are taught to hide in closets, and politicians are frequently incapable of agreeing on a common response to those recurring images that are seared into our minds, and certainly into the minds of children as they're taught how to try to escape from gunmen who are visiting their schools. And so on this week in which the people who occupy the highest posts of the federal government of the United States change, it's especially appropriate to focus on a policy that has received support across political differences for many years, and that's the use of imprisonment to enforce immigration law. When they struggle to agree on anything else, when basic facts are disputed, Republicans and Democrats consistently and repeatedly display a willingness to lock up migrants. Today, immigration holding facilities, inside immigration holding facilities, you can find just about every type of person, from toddlers seeking asylum to lawful permanent residents of the United States with decades in this country and an equally long criminal record to prove it. Immigration prisons display the complexity, and they also display the contradictions of migration. Look hard enough and you can find models of innocence, those children who are too young to be asked for their opinions. But look hard enough and you can also find models of repulsion, adults who have committed the most heinous of acts. In multiple chapters in my first book, Crimmigration Law, which came out in 2015, I mapped the legal doctrine of immigration imprisonment, how people get in, how people can get out of immigration imprisonment in the United States. I explored the details of the legal mechanisms and the procedures that lead to immigration imprisonment across several academic articles, including Abolishing Immigration Prisons, which you may have received upon registering for this gathering. And more recently, I mobilized this background in Migrating to Prison, America's Obsession with Locking Up Immigrants, the book that Mary so kindly mentioned, that came out just over a year ago. Migrating to Prison reminds us that the United States has not always done things as we do them now, nor was it inevitable that we would adopt this particular policy and legal course. Courtroom arguments and on-air debates about immigration law enforcement policy often overlook that immigration imprisonment developed out of a fear of people categorized as racially undesirable. And it thrives because of corporate profit and political windfall. All the while, there are real people who are suffering. And this is why I've concluded that immigration prisons are not defensible. And so we should abolish them. I'll use the next 30 minutes or so to describe the immigration prison system that exists today, how we got here, and why it continues to grow. And then I'll begin to lay the groundwork for imagining a world without immigration prisons. And finally, I'll reflect on immigration law's embrace of criminality to determine who is allowed to remain in the United States. To do that, first let me ask you to take a step back in time with me. So it was 1954, and Dwight Eisenhower was the president, was in the White House. And in a move that today sounds like mere fantasy, his attorney general, the country's top law enforcement officer, the head of the Justice Department, announced in November of that year that the United States would stop detaining migrants even if they clearly lacked permission to be here. So in November of that year, the New York Times, reporting on this policy, wrote, "The last detained alien, a Norwegian seaman who had overstayed his shore leave, was a passenger on the Battery-bound ferry." The Battery is in southern Manhattan. 4 years later, Justice, now 1958, Justice Tom Clark, who's writing in an opinion on behalf of the U.S. Supreme Court, explained, physical detention of aliens is now the exception, not the rule. Certainly, this policy reflects the humane qualities of an enlightened civilization. Well, just as it was possible to take a turn toward enlightenment, in Justice Clark's words, it was also possible to take a turn away. And so we did. When dark-skinned migrants began arriving in the United States without the federal government's permission in the late 1970s and early 1980s, federal officials turned to prisons. First, there were the Haitians, hopeful that in the United States they could escape political and economic turmoil. Those were the last years of the Duvalier regime. And the administration of Democratic President Jimmy Carter confined them. Within a few years, Cubans leaving the island from the port of Mariel joined Haitians on their northward trek. And the administration of Republican President Ronald Reagan expanded and formalized earlier detention policy. By the mid-1980s, Haitians and Cubans had been eclipsed by Central Americans who were seeking safety from the violence that was racking that region. And they too were imprisoned. They were sent to federal penitentiaries. They were sent to military bases, to prison-like detention centers run by the now non-existent Immigration and Naturalization Service. And let me tell you about just one of these people, these Central Americans who were coming to the United States in the 80s, a teenager named Jenny Flores. Her birthplace, El Salvador, was in the midst of war. When Jenny headed north, the INS, when she got here, the Immigration and Naturalization Service, the INS, locked her up in a converted hotel surrounded by concertina wire. That's that barbed wire that runs along fences. She was forced to remove her clothing, and she was strip searched. Actually, she was cavity searched. She sued and became the named plaintiff in what's referred to as the Flores Settlement Agreement, the binding agreement between the Federal Justice Department and Jenny Flores and other children who are detained by federal immigration officials. And it's that Flores Settlement Agreement that still, to this day, sets the bar for the government's treatment of detained children. Now, with support from Democratic President Carter, and then support from Republican President Reagan, immigration imprisonment began with bipartisan support, and it has continued to enjoy bipartisan support. After Reagan, his successor, Republican President George H.W. Bush, the elder Bush, kept people in Guantanamo, Cuba. Now, this was a decade or so before his son, George W. Bush, would use the same location to hold people caught in Afghanistan and Iraq and in the wars that followed the attacks of September 11, 2001. While George H.W. Bush, the elder, held migrants there in Guantanamo, advocates criticized him mercilessly. After his defeats by the Democratic President Bill Clinton, for a time, federal immigration officials continued detaining migrants there, rebuffing those pleas and promises during the campaign to stop doing that. Well, next was the Republican George W. Bush, and he separated parents from their children. And when it learned of this, Congress balked. And so Bush relented by building a detention site in Texas where families could be confined together. His successor, the Democrat President Barack Obama, shut down that facility within a few months of beginning his term in office. But then a few years later, in 2014, Obama actually opened up to other sites, to similar sites. Family residential centers, the government calls them to this day. Critics to this day use the phrase baby jails. And as I imagine many of you are aware, President Trump separated families. In the summer of 2018, the Trump administration's practice of separating families, of criminally prosecuting the parents and detaining children was in full bloom, not just in the United States, but around the world. Now, Trump's Attorney General at the time, Jeff Sessions, explained the administration's policy in this way. If you cross this border unlawfully, then we will prosecute you. It's that simple. If you are smuggling a child, then we will prosecute you, and that child will be separated from you. Well, for a time that summer, Kristen Nielsen, who is then the Secretary of Homeland Security, the federal department that houses both the Border Patrol, the Border Police Force, but also the Interior Immigration Police Force, the Immigration and Customs Enforcement Agency, Secretary Nielsen denied that this was happening. She went on to describe journalists and advocates as, quote, irresponsible and unproductive for pointing to what everyone could see. Eventually, she stopped denying. And that brings me to immigration imprisonments present. Today, immigration prisons are everywhere. They take just about every form. There's an old motel in Tucson, Arizona, to a collection of county jails in northern New Jersey, not far from New York City. Some people, like Jenny Flores, are held in these places because they dared to seek safety in the United States. Other people flouted government requirements about the proper way of arriving. Coming here without the federal government's permission is a federal crime. It's a misdemeanor, punishable by up to 6 months imprisonment for a first-time offense. Its close cousin, unauthorized re-entry, is also a federal crime, only it's a felony, punishable by up to 2 years imprisonment for a first-time offense. There's actually some sentencing enhancements that make a 20-year prison term possible, although admittedly, no one, I've never heard of anyone getting anything near that length of a sentence, though it's possible. Now, still others are locked up because the government wants to strip them of the permission that they already have to be here. As an example of this, take a man named Jerry Armijo. He was raised in South Texas, okay, not far from where I grew up. And so we were both born into what is a poor, one of the poorest regions of the United States, overwhelmingly Mexican communities. Only I was born north of the Rio Grande River in the US state of Texas. And Jerry was born on the southern side of the river in the Mexican state of Tamaulipas. So as a result, I was born a United States citizen and Jerry was not. Well, after I finished high school, I went off to college. And Jerry went off and joined the United States Army, which then sent him to Iraq. And he joined a battalion of tanks. So while I was in college, being shocked by a different culture in New England, state of Rhode Island, Jerry was in Iraq, patrolling the desert. And so he was shocked one day by exploding bombs. His tank, as he was patrolling, went over an IED, and the bomb blasted right through the bottom of the vehicle. It injured Jerry, did not kill him, but he suffered a leg injury and he suffered post-traumatic stress disorder. And so he got sent back to Texas, ostensibly to recover. And when he did return to Texas, he did not get the support that he apparently needed. So not the medical support, not the emotional support, not the financial support. And so he fell into drugs. and then into the criminal justice system. And one day, as he was going through the criminal justice system, as he was going through the criminal court system, he just stopped showing up for court dates. And it turns out that he had been picked up by the Immigration and Customs Enforcement Agency, the federal government's immigration police force. ICE, as the agency is usually called, arrested him, and they sent him to a nearby immigration prison. Well, across the United States, the federal government runs a network of immigration prisons. And to do this, it relies on 5 agencies primarily. There's the Customs and Border Protection Agency and the Immigration and Customs Enforcement divisions. Both are divisions of the Department of Homeland Security. There's the U.S. Marshal Service. There's the Federal Bureau of Prisons. And then there's the Department of Health and Human Services Office of Refugee Resettlement. Primarily through the Border Patrol agents, Customs and Border Protection apprehends and detains people along the border who it suspects of having entered the United States without the government's permission. And it famously keeps them in small cells designed for short-term use inside larger Border Patrol stations. In my native South Texas, these often resemble large dog kennels, enormous cages built of chain link fencing. CBP's cousin agency, ICE, is responsible for detaining people who the federal government's trying to figure out whether they're going to be allowed to remain in the United States. And to do this, it relies on hundreds of facilities all over the country, most of which are nothing more than county jails that are owned by local governments. These are jails that are usually run by a county sheriff's department. And ICE essentially pays the sheriff a daily rate for beds reserved for its use. In effect, ICE is renting bed space from the county sheriff. Now, other facilities in ICE's network are standalone facilities that are owned or operated by private prison corporations, and the 2 biggest players in this market are CoreCivic and the Geo Group. Not far from where I'm sitting right now in Denver, there's actually a private prison in the Denver suburb of Aurora that houses plus 750 or so people on a given day. Now, for its part, the U.S. Marshal Service is responsible for pretrial confinement of migrants who are suspected of violating a federal crime, including an immigration crime like illegal entry, unauthorized entry, and unauthorized reentry that I mentioned earlier. And after people who are prosecuted for federal crimes, including those, are convicted, and when it comes to people prosecuted for unauthorized entry and reentry, almost all of them are convicted. They're handed over to the Federal Bureau of Prisons for punishment, and the Bureau of Prisons sends them into its own network of prisons, which are around the United States. And the last of the federal agencies with a significant role in imprisoning migrants is the Office of Refugee Resettlement, or ORR. ORR does not run its own facilities at all. Instead, it contracts with non-governmental organizations to house the migrants that are in its care, specifically children. ORR's main customer is Southwest Keys, an organization that runs about 24 sites on behalf of the agency. In Tucson, Arizona, Southwest Keys uses that converted motel that I mentioned earlier. In Brownsville, Texas, for a while they were using an old Walmart. It's a big sort of cavernous facility. And so some people enter, some people are exiting the immigration prison network. And as this happens, migrants are counted and they're commodified. The federal government spends billions of dollars on immigration prisons every year. And this largesse is welcome news to private businesses, obviously, but also local governments. And 3,000 person Milan, New Mexico. 300 people work for CoreCivic, one of the 2 largest prison operators in the United States, private prison operators. So to elected officials, the threat to their high employment private prison is a threat to their reelection bids. When the Bureau of Prisons announced that it was cutting off the Milan prison, a local elected state representative said this, said, "My first option is for it to stay open, for it to stay private because of the revenue the prison produces for the city of Milan." Well, soon the prison had another customer, the Immigration and Customs Enforcement Agency. So no one went without a job. So with support from Washington down to New Mexico, rural New Mexico, it seems that the future is bright for immigration prisons. After all, in this topsy-turvy world, our collective moral compass has swerved to the point that we no longer really debate whether we should lock up children. Instead, detaining children with their mothers is offered as the humanitarian response to taking children from their parents. And so this is why I've come to abolition. Instead of an immigration law enforcement strategy that is afraid that migrants will pour onto our streets and into our schools, I imagine a different future. I imagine a future in which immigration prisons do not exist. And I acknowledge, first off, that this is definitely a long, winding road. And I do not have all of the answers that could get us from here to there. But I do have some thoughts on how we start heading in that direction. Beginning with the fact that immigration imprisonment is not really about the rule of law, nor is it about right or wrong. It's about the politics of fear, refracted through the dirty prism of racism. Today, immigration policing is racially skewed. Government reports tell us that tens of thousands of Europeans violate US immigration law every single year. And yet, ICE's prisons are not overflowing with Western Europeans. Almost all of its detainees hail from Latin America. Today, immigration policy embraces myths that migrants are boogeymen. To President Trump, they're rapists, they're beheaders. To President Obama, they're felons, not families, as he memorably put it in November 2014. Today, immigration law embraces fantasies that migrants are aliens. But aside from Superman, the most famous alien, patriotic alien in the history of US culture, I think, migrants are not aliens. Migrants are just people. And like most people, most of the time, migrants are profoundly ordinary. We in the United States like to imagine ourselves as exceptional. And when it comes to migrants, we demand of them the exceptionalism that we imagine in ourselves. And so I think it's long past time that we remove myth from the center of immigration law and policy. Over the centuries, restrictions on migration have been dotted by various iterations of an ideology of segmentation and segregation. Indeed, immigration law is anchored in our nation's original sin, slavery. The federal Constitution's only explicit reference to migration comes in the form of the Migration Clause, a bar on congressional attempts to stamp out slavery before 1808. That is, the only explicit mention of migration in the US Constitution protected forced migration in the form of slavery in the first decades of the country's history. The nation's first naturalization law limited full participation in our political community to, quote, free white persons, although others were deemed unworthy of citizenship. And the modern era of immigration law began in the late 19th century during an era of racist bars to migration that began with Chinese exclusion before expanding to reach citizens of most Asian countries. They were quite simply deemed undesirable residents of this nation. What began as an important legal dimension of white supremacy, migration restriction remains mired in the worst moments of our nation's past, even if law's prism, reflecting not logic, but human experience, to paraphrase Oliver Wendell Holmes in the common law. And it now shapes that light differently. Today, the overt emphasis on racial restrictions has been replaced by a bipartisan commitment to targeting people stained by the criminal justice system. For the last few decades, the United States Supreme Court recognized in the 2010 decision by the versus Kentucky, for the last few decades, the United States has witnessed what the court described as a steady expansion of deportable offenses and a reduction of options to escape the immigration, prison, and deportation pipeline. The court wrote, Under contemporary law, if a non-citizen has committed a removable offense, his removal is practically inevitable. Well, that was not always so, and it should not always be so. I'm currently developing a robust defense, what I hope will be a robust defense of migrants who commit crime, the people who politicians like to refer to as criminal aliens, arguing that crime should bear no weight when determining who is allowed to remain in the United States. This project, which I'm calling In Defense of the Criminal Alien, puts at the center of my analysis our flaws as individuals and as a political community. And it offers an expanded sense of citizenship. Before the middle of the 20th century, migrants could not enter citizenship if they were racialized as undesirable. At the same time, migrants could enter citizenship if they pillaged, raped, or murdered, as long as they did so more than 5 years before applying for naturalization. Louis Loftus Repullier did not wait. An aspiring US citizen, there was no question that Mr. Repullier had murdered someone. In the words of Judge Learned Hand's opinion for a federal intermediate appellate court, let me just read the passage from the judicial opinion. On October 12, 1939, he had deliberately put to death his son, a boy of 13, by means of chloroform. He soaked the rag in chloroform, walked over to the bed where the child was laying, and suffocated the boy. For 4 years, he did that. He was found by a neighbor at the bedside. Never denied that he did it. 4 years, 10 days, and 1 week later, he applied for naturalization. That was too soon for congressional taste. Had he just waited a few more weeks, Judge Learned Hand wrote, let me just read the passage. He would have been admitted without question. The pitiable event, now long past, will not prevent Repullier from taking his place among us as a citizen. Well, today, federal law is clear. Murder is an aggravated felony, and an aggravated felony conviction at any time means no good moral character, without which naturalization is off the table. Today, there's little room for criminals among the citizenry, except, of course, that the citizenry is full of criminals. The angry insurrectionists who stormed the US Capitol in Washington, D.C. just 2 weeks ago are only the latest, most vicious, most prominent example of US citizens embracing violence and criminality. Let's imagine for a minute that one of those who attacked the Capitol was not a US citizen. Many people believe they are US citizens, indeed have no reason to believe that they are not, when as a matter of law, they are not. Many people who are not US citizens and know they're not US citizens nonetheless support President Trump. Would the United States be better off deporting that person? Would another country be better off welcoming into its ranks someone who is willing to attack the United States Capitol in the full light of day? And all the journalism coverage and all the political commentary that has followed the January 6th attack, no one has asked about the possibility that in that crowd of tens of thousands of mostly white people, there might have been someone who is not a US citizen. Meanwhile, people of color are frequently villainized. In 2015, Republicans and Democrats tarred a man named Jose Garcia as a fiend. They pointed to him as the diabolical face of liberal failures to crack down hard enough on migrants. Dianne Feinstein, the Democratic US Senator from California, criticized San Francisco for failing to keep him locked up. President Trump lamented, as he put it, beautiful Kate Steinle, beautiful Kate Steinle, the young white woman who died when a bullet dislodged from a gun that Garcia Zarate was holding hit her. He was arrested and he was charged with murder, and the jury acquitted him. Yes, he was holding that gun when the bullet dislodged, but the gun was wrapped in a cloth they found under a park bench. The prosecutor failed to show that Garcia Zarate even knew what was inside the cloth. Redemption for some, punishment for others. When this is the state of affairs in the criminal justice system, adding immigration consequences only further subverts the legitimacy of the legal system. Instead of repeating the pattern, I suggest a reimagined sense of citizenry, embracing the US legal tradition's historical aspiration of redemption in defense of the criminal alien urges a conceptualization of the citizenry as what it is, a motley collection of outcasts and scoundrels, of misfits and deviants. And then there are all the rest of us who top off at just plain boring. Ordinary people living mundane lives, peppered by those moments in which we fall short of our own unexceptional standards. These are parts of ourselves which are always there. These are the parts of ourselves from which often we hide. These parts of ourselves which individually evolve. Today we're flawed in this way, and tomorrow we will be flawed in some other way. These flaws form a category of trait that is cumulatively immutable. Our imperfections change, but imperfection defines us. These are the parts of ourselves that are the stranger within us. To borrow the language of immigration law, this is the alien. The alien has arrived. He is here inside me. Indeed, he always has been, and he is not going anywhere. So we might as well just get used to him. Instead of trying in vain to cast out the alien, we should correct our distorted self-image and look to atone for immigration law's self-righteousness by embracing the alien in our midst. All of them. Thank you. I'll stop there and I look forward to your questions and your comments.